The Constitution in Article 49 says clearly, rights of arrested persons. One of those rights, I will not go through all of them, in 49(1)(b) is to remain silent. Our colleague, Mr. Chacha, is under no obligation to help the prosecution or the investigator do his work. Let the investigator do his work as he pleases. In any event, why arrest before gathering information? The confirmation that the arrest was totally premature is the fact that 17, almost 20 days later, they cannot manage even a holding charge. They are just asking to extend days of detention. They are not sure. Of the 17 days, almost 20 days he's been in custody, because from the 14th, today is the 1st. So this is the 17th, is it the 17th? Yeah. 17th day. They have questioned him only on 2 days, namely the 21st, a whole 7 days after arrest. On the 21st is when they questioned him, and again on the 26th for 5 minutes. On the 26th. We do not...
21st and 26th.
26th and 26th specifically for 5 minutes, he says. So because we do not want to ask you for time to make a replying affidavit, we want to request the court to let him make a very short statement under oath. Because what is an affidavit? It's a statement under oath. Let ours be oral, under oath. And because of equality of arms, since we have not been able to cross-examine the deponent of the affidavit, we shall also not be offering Mr. Mwita for any cross-examination. You just make a short statement from where he is, so that the court may get to the end of this matter and Mr. Mwita may walk out of the dock and go home to his family as he should. So perhaps, so that we are methodical, I can finish the few points I had from the prosecutor's mouth.
You know, perhaps I
have not finished. No, Mr. Muridi was told not to interrupt you. I will request that you sit. You do not affect my train of thought. I finished just like I also begged even Mr. Muridi to direct you.
Perhaps,
you have
Your
time.
Honor, may we get direction, since counsel has just made an application that we have not.
I have understood counsel to say
yes,
that she wishes to conclude
first.
Yes,
and then formally launch that application.
Very well.
We will have an opportunity to respond to that application.
Very well. Thank you.
And when we give you leeway, give us leeway as well. So what we are saying, Your Honor, is that not even a court of law can order Wakili Chacha to help the police, to give them the password. He has a right to remain silent to any question. In any event, they have already gotten data without him from one phone. In other words, the anti-terrorist forensic unit, they are able to crack the phone. They've already cracked one. What is stopping them from cracking the second one? Why do they have to ask the participation of Mr. Chacha, who is actually under Article 50, presumed innocent? this court and everybody must presume Mr. Chacha as innocent until proved guilty. So are the police trying to show their powers that they can detain him? The prosecutor says for 365 days, that they have more days remaining. He couldn't be more wrong on law. If you look at the Constitution, a person has to be brought to court as soon as possible, within 24 hours. That's the same Article 49F of being arrested. So all they have without permission is 24 hours, and they ended a long time ago. They asked the court for 15 days, 20 days, they were given 15. They have only utilized 2 out of the 14. 12 days they went to sleep, or to slumber, if you like. They are now saying, give us another 14, we will take our sweet time, and we will punish Mr. Mwita by taking away his liberty, even though he's presumed innocent. So they are telling the court to aid and abet this injustice of keeping a man presumed innocent in custody. This affidavit that has come today does not say why they could not utilize fully the 14 days. It is clear indication, even if you give them more days, it's games they are playing, not investigations. Of the fundamental rights, the foremost right is the right to life. Below it is the right to liberty. After the right to life, I do not know of any other right that ranks higher than liberty. And the court can only withhold a person's liberty with enough reasons to do so. We are asking you to decline the invitation to assist the prosecution keep Mr. Mwita in custody for more than already have. If they were unable to utilize 12 days, and the second day they only utilized 5 minutes, they have finished with their investigations. Let the court not aid or abet abuse of the process. You have heard for yourself, Your Honor, that the idea, the understanding of the prosecution is that they have a whole year, 365 days. So they might keep on asking you for 14 days and also demanding the balance of 365 days. That's the way they understand it. We understand it differently, that the reason why one has to be brought to court within 24 hours is because liberty is so important that it cannot be left to the whims of investigators. We are therefore urging you today to let Mr. Mwita go home. He's an officer of this court. He will make a short statement of the nature of the investigations, because we would have done that so that the court knows exactly the questioning that he's been subjected to in the 2 days, and therefore the court understands the kind of game being played by the prosecution. Even if Mr. Mwita goes home today, they still can go ahead and crack the second gadget, the same way they did the first, and then decide which charge. He is ready to abide by whatever terms the court will give him. There is absolutely nothing new in today's affidavit except the allegation that he refused to cooperate. And refusing to cooperate means he did not give them the PIN. They had already removed the SIM cards. He will say that for himself. He will say what happened, actually transpired. I would ask my colleagues if any of them has short additions so that we do not take time. We believe that the prosecutor, because what he said in so many words was just that Mr. Mwita did not give the PIN. He also gave his view of the Constitution that the Terrorism Act is greater than the Constitution, which is not true. He also gave his view that he has 365 days. We do not want to take the court's time because we would like the ruling of the court, because there are not many issues involved here.
My colleagues have said, and I wish to be associated with their submissions, all of them, is that they did not do any investigation. And they are here now telling you that we want to detain Mr. Andrew Chacha Mwita for further 365 and a quarter days. Kwa hayo machache, mheshimiwa, uvuvi huu wa ushahidi lazima ukwishe. Waswahili husema mbio za sakafuni huishia ukingoni. Walikimbia hapa na hizo mbio zao. Ni jukumu la haya mahakama, hii mahakama, kuziweka hizi mbio za sakafuni